Ready, start. Will is defined as wish, desire, pleasure, inclination, choice, the faculty of conscious, and especially of deliberate, action, full stop. It is purely and solely a mental process to be ascertained, in a prosecution for rape, by what the prosecution witness may have said or done, full stop. It being a mental process, there is no other manner by which her will can be ascertained, and it must be left to the jury to determine that will by her acts and statements, as disclosed by her evidence, full stop. It is but natural, therefore, that in charging the jury upon the subject of rape, or assault with intent to commit rape, the courts should have almost universally, and in many cases, exclusively, discussed consent and resistance, full stop. There can be no better evidence of willingness in a condition or state of mind, no better evidence of unwillingness than resistance, full stop. No lexicographer recognize consent as a synonym of willingness, and it is apparent that they are not synonymous, full stop. It is equally apparent, on the other hand, that the true relation between the words is that willingness is a condition or state of mind and consent one of the evidences of that condition, full stop. Likewise, resistance is not a synonym of unwillingness, though it is an evidence thereof, full stop. In all cases, therefore, where the prosecuting witness has an intelligent will, the court should charge upon the elements of consent and resistance as being proper elements from which the jury may infer either a favorable or an opposing will, full stop. It must, however, be recognized in all cases that the real test is whether the assault was committed against the will of the prosecuting witness, full stop. Broadly, this court has accepted and followed the judgments referred to in the above judicial dictionaries as regards the meaning of the word consent as occurring in section 375 IPC, full stop. It is not necessary to refer to all the decisions, and the reference to two decisions of this court shall suffice, full stop. In state of HP versus Mango Ram, three-judge bench of this court, while dealing with the aspect of consent for the purposes of section 375 IPC, held at page 230 of the report as under: submission of the body under the fear of terror cannot be construed as a consented sexual act, full stop. Consent for the purpose of section 375 under bracket 5 requires voluntary participation not only after the exercise of intelligence based on the knowledge of the significance and moral quality of the act, but after having fully exercised the choice between resistance, assent, full stop. Whether there was consent or not, is to be ascertained only on a careful study of all relevant circumstances, full stop. In the case of Uday versus State of Karnataka, this court put a word of caution that there is no straitjacket formula for determining whether consent given by the prosecutrix to sexual intercourse is voluntary, or whether it is given under a misconception of fact, full stop. The court at page 57 of the report stated, in the ultimate analysis, the tests laid down by the courts provide at best guidance to the judicial mind while considering a question of consent, but the court must, in each case, consider the evidence before it and the surrounding circumstances, before reaching a conclusion, because each case has its own peculiar facts which may have a bearing on the question whether the consent was voluntary, or was given under a misconception of fact, full stop. The appellant filed a complaint under Section 138 of the Negotiable Instruments Act, 1881, full stop. The accused, on being summoned by the magistrate, filed a petition before the High Court under Section 482 CRPC, inter alia, praying for dispensing with her personal appearance before the magistrate full stop, the single judge of the High Court, while allowing the petition and permitting the accused to appear before the trial court through her counsel, issued general directions to all the criminal courts as regards holding of trials, particularly, in cases involving offences under Section 138 of the NI Act, as also in all other cases involving offences technical in nature and not involving moral turpitude. Full stop. The appeal filed by the complainant was listed before a division bench of the Supreme Court, which felt the necessity of referring the matter to a larger bench and, thus, the appeal was referred to the three-judge bench to consider the question whether the High Court, in exercise of its jurisdiction under Section 482 and 483 of the Code of Criminal Procedure, 1973, and slash or under Article 227 of the Code of Criminal Procedure, 1973, and slash or under Article 273 of the Constitution of India, could issue guidelines directing all courts taking cognizance of offences under Section 138 full stop